po dito. No? That's basically our point. And then secondly, the decision earlier, it was mentioned by distinguished opposing counsel, decision rests upon this court to determine kung meron ng unexplained wealth. I disagree with that. The ultimate decision rests upon this court, that is true. But the initial decision rests with the person accusing, di ba? Pero nung nag-accuse yung tao sa Sabayan Cabrera complaints, wala man lang nakasulat po doon. Kanina na-mention po yung should the Committee on Justice now conduct a full-blown trial? No, it shouldn't. It should just evaluate the complaint. Para nga pong piskal, parang preliminary investigation. Pag tayo po pumunta sa piskal at ang dala lang natin doon ay puro paratang, wala man lang supporting document, what will the fiscal do? Dismiss the case outright. Yan naman po ang totoo. No? So that was our point to begin with, and that is why we're saying fishing expedition ito. Kasi hindi mo man lang ma-pinpoint kung anong transaction yung sinasabi mong nag-amass ang Vice President natin. Anong taon na nag-amass yung Vice President natin ng ill-gotten wealth or unexplained wealth? At dahil doon, ngayon, we're asking for records spanning 20 years, both BIR records, bank records, AMLAC records, which they already have, actually, from the Committee on Justice. Pero, hindi natin ma-pinpoint, alin ba talaga dito? We cannot specify kung ano yung act, ano yung omission na ginawa niya na nakapag-amass siya ng unexplained wealth.
Talking about both parties talking about the fiscal or prosecutor, actually binago na rin ngayon. Probable cause with reasonable certainty mako-convict. So meaning you go to the fiscal's office that you point out ano yung crime, sino yung gumawa ng crime, and yung preliminary evidence mo might not be enough to convict at that time, but enough to say na hindi lang to marites. So if I go to the fiscal's office or ombudsman saying this senator has 150 million in SALN, 10 years ago it was 50 million, therefore it's ill-gotten wealth, and then wala pa akong ibang dala except yung magkano sweldo dito, I doubt the fiscal will file that case. But if I tell the fiscal that he has 2 cars in his SALN, but eto, I see him using 4, then give him the opportunity. But I can subpoena the LTO. Na kanino ba yung plate number na yan? Baka namang nasa kapatid talaga niya, no? But the last set of questions, I'll just ask it once, no? So I think everyone understands naman the subpoena regarding the Vice President. The issue was really the dates and how specific or hindi. Actually 2 questions. The corporations, do you not have to pierce the corporate veil, considering there's no allegations in the articles that these companies were used to amass ill-gotten wealth? In fact, I haven't read everything, but so far sa binasa ko, is hindi kumikita tong mga kumpanya na to. Because there's a Supreme Court decision that if it's a joint account, may rights din yung isa. And I don't even know if we informed all of those companies that we might subpoena their records. So did we give them that opportunity? Isama ko na yung last question, Mr. Presiding Officer, and I won't follow it up, no? But yeah, the question was, because a law student asked me, Sir, bakit dinala yung box dito sa Senate? Ba't na lang hindi nila binuksan sa House? So sinagot ko sa kanila, ano ba turo ng professor nyo? Sir, hindi naman nakalagay impeachment trial in cases of impeachment. So the House was actually empowered to open the box there. So I just wanna know the position of both parties kasi nahihiwagaan ako sa box na yon. Sinil, dinala dito, ibabalik sa inyo, then magsusupina tayo. But dun sa graduate na yung nagtanong sa akin doon, they discussed it daw in class, and their professor and their class, ang consensus is that the House could have opened it because the wording in the is it the BIR case or the bank accounts? No, bank accounts ata, yung in cases of impeachment, yung nakalagay dun sa,
Yes,
sa
Bank
batas.
accounts. Secrecy of bank deposits.
Yes. So ang question niya, let me rephrase, is that, did you do that there? Kasi if you did that there, hawak nyo na ngayon. Hindi na namin problema sana. No? So those two questions lang regarding the, do you think nag-comply yung requirements dun sa companies and should we give notice to the companies? And secondly, about bank account, could you have opened it already in the House? Yung BIR din ba?
Counsel for the panel of prosecutors may respond. Thereafter, counsel for respondents.
Thank you, Your Honor.
Presiding
And we would
Officer.
like to thank
Counsel, thank you very
Senator
much.
Judge
Thank you,
Allen for his
Senator
interjections.
If Your Honor, please, the doctrine of piercing the corporate veil applies when we are determining liability of the company or corporation involved. In this particular case, that doctrine has no application at all. We are asking for those records to be produced so that we can determine the extent of participation of the Vice President, as she herself had admitted those business interests in her SALENS. Kaya po namin hinihingi po yun. Kasi sa tingin po namin ay wala pong aplikasyon ang piercing the corporate veil. Second, as far as opening the box is concerned, while it is true that under Republic Act 1405, there's no qualification that impeachment trial lang po ang pwede. As I understand it, it was the better judgment of the committee out of sheer discretion and prudence not to, because at that time we were already being bombarded with petitions left and right seeking to restrain our proceedings. And we felt that it would be more prudent to bring the matter to this honorable court. Thank you.
Your Honor.
Counsel for the respondent.
On the first point, Your Honors, on piercing of the corporate veil, para sa amin, pwede lang naman under jurisprudence mag-pierce ng corporate veil. Ibig sabihin, kasi separate and distinct personality ng mga korporasyon, you can pierce that veil if there's an allegation of fraud. And in this case, wala naman pong allegation ng fraud. Pangalawa, kung totoo po na talagang hinahanap lang po ng kinakagalang-galang na prosecution ay tungkol dun sa divestment issue, then they will not need the tax records, the bank records, or even the AMLAC records of these companies because all they need would be the GIS. The General Information Sheet would show you exactly the extent of the interest of the stockholders, hindi po ba? Pangalawa, pagdating naman po dun sa what's our position, pagdating sa bank secrecy and the exception on cases of impeachment. Sa aming pananaw, at the committee level, meaning Committee on Justice, ay hindi pa po applicable yung exception na ito. And we are holding on to the ruling of Marquez versus Ombudsman or Desierto, I believe, no? Wherein it was said na pagdating sa preliminary investigation, hindi pa po applicable yung mga exceptions under the Bank Secrecy Act, and there has to be a pending case before such bank documents are in fact subpoenaed. That is our position, Your Honors.
Thank you, counsels for the parties. Chair will now make a ruling, but prior to that ruling, Chair would like to inquire very, very briefly from the counsels. First, for the counsel for respondent, may the court know when the respondent was married to her spouse and what is the property regime governing their marriage?
Your Honor, I believe they were married, but let me just check the facts just to be sure, but I think it was 2007. 2007, Your Honor. Can I get back to you on the specific date for that?
The date would not be necessary because 2007 would mean they would be covered under the family code. So may the
Yes, Your Honor.
chair ask, what is the property regime governing their marriage?
As far as I know, there are no property regime arrangements or prenup. That's why, Your Honor, I would assume it would be the default property regime, which would be
The absolute community of property. Thank you, counsel. Chair will now make its ruling. The impeachment court will now resolve the prosecution's renewed request for the issuance of subpoena ducis tecum dated July 6, 2026. You may seat, counsels. Directed to the concerned banking institutions and Anti-Money Laundering Council. The court begins with the standards governing the issuance of subpoena ducis tecum. These are set forth in Section 3, Rule 21 of the Rules of Court, which provides, among others, that In the case of a subpoena ducis tecum, it shall contain a reasonable description of the books, documents, or things demanded, which must appear to the court as prima facie relevant. Settled jurisprudence has affirmed and clarified these requirements in the 2021 case of Republic versus Sandigan Bayan, dated 2/15/21, where the Supreme Court stated, quote, "A subpoena ducis tecum may be issued if the tests of relevancy and definiteness are satisfied. The court must ensure that, number one, the books, documents, or other things requested must appear prima facie relevant to the issue, subject of the controversy, the test of relevancy. And number two, such books must be reasonably described by the parties to be readily identified, the test of definiteness." In the case of BSB Group Inc. versus Go, GR number 168644, the court stated that evidence is relevant when it bears such a direct relation to the fact in issue as to induce a belief in its existence or non-existence, and when it relates to a collateral fact from which the existence or non-existence of the principal fact may logically be inferred. These requirements are intended to ensure that the subpoena is not used, as mentioned earlier and discussed earlier, as a tool for a fishing expedition as held in Apostol versus Lubingan Rafael, GR number 260640, dated October 1, 2025. We are also aware of the ruling of the Supreme Court in HC Libanao versus Philippine National Oil Company, GR number L13463, quote, "A general inquisitorial examination of all the books, papers, and documents of an adversary conducted with a view to ascertain whether something of value may or may not show up will not be enforced. However, after a careful examination of the records requested, the court finds that the requested documents meet the requirements set forth above. They are reasonably described, readily identifiable, prima facie relevant, and material to the allegations under Article 2. This is not the first time that bank records have been examined by an impeachment trial. During the impeachment trial of former Chief Justice Corona, the Senate, sitting as an impeachment court, granted the prosecution's request for the production of bank records. In granting that request, the court cited Section 2 of Republic Act No. 1405, which expressly recognizes cases of impeachment as an exception to the confidentiality of bank deposits and the rights to privacy of depositors. As to the requested period from 2007 to 2021, the defense's objection is overruled. The respondents' invocation of what they refer to as offenses in term, quote unquote, in their memorandum, doctrine in Duterte versus HOR, does not avail. First, the documents requested under the subpoena ducis tecum will not be used to allege additional independent impeachable offenses. The court will not allow this in adherence to the doctrine laid down in Duterte v. HOR, as this will violate the respondent's right to be informed of the nature and cause of the accusations against her and her rights to due process at every stage of the proceedings. Rather, the court will only allow these records to be used to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. Establishing such a factual baseline is recognized in settled jurisprudence involving allegations that a public officer's wealth is manifestly disproportionate to the lawful income and financial capacity of the officer and the officer's spouse. As held by the Supreme Court in Concerned Taxpayer versus Doblada Jr., dated 8 June 2005, quote, "In determining whether the properties acquired were manifestly out of proportion to the lawful income of the spouses, necessarily requires comparing their value with the spouse's salaries, benefits, other lawful income, and revenues from legitimately acquired properties or businesses." Further, in the case of Ombudsman V. Bernardo, GR number 18-1598, quote, "Respondents' beginning net worth must be considered for purposes of determining whether his disposable income was more than sufficient to justify his property acquisitions and foreign travels for the covered period, and whether he possesses the financial capability to acquire or purchase properties as reported in his SAL-N. Quote, "Such net worth of the respondent as declared in the statement filed by him or her from the first day of his employment with the government shall be considered as his true net worth as of such date for purposes of determining his capacity for future property acquisitions during his tenure as a public officer. Any unexplained increase in his net worth thereafter may fall within the ambit of the presumption provided for in Republic Act Number 1379. The production, therefore, of the records from 2007 to 2021 is authorized strictly for that limited purpose only. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term in relation only to Article 2 of the Articles of Impeachment. Now, with regard to the bank records held separately by Attorney Manasseh Carpio and jointly by him and the respondent, the defense's objection is likewise overruled. The respondent's reliance on Republic vs. Eugenio is unavailing. That case involved only an ordinary civil inquiry into spousal assets that were not statutorily aggregated. On the other hand, Section 8 of Republic Act number 6713 requires public officials to disclose their assets, including that of their spouses. Their financial interests are therefore statutorily intertwined for purposes of disclosure. Respondent likewise insists on the separate legal personality and distinct right to privacy of Attorney Carpio, but this is likewise untenable. Article 75 of the Family Code explicitly provides, which is why the presiding officer earlier asked the property regime governing them. In the absence of a marriage settlement or when the regime agreed upon is void, the system of absolute community of properties established in this code shall govern. Under this regime, Article 91 dictates that community property shall consist of all the property owned by the spouses at the time of the celebration of marriage or acquired thereafter. Furthermore, the Family Code imposes a strict statutory presumption under Article 93, which mandates that property acquired during the marriage is presumed to belong to the community unless it is proved that it is one of those excluded therefrom. The law is clear on the matter. The legal necessity of examining the financial records of Attorney Carpio is firmly cemented by the default property regime of absolute community of property governing his marriage to the respondent. Absent any proof of a different property regime governing their marriage, any funds deposited in the bank accounts of Attorney Carpio are legally presumed to form a single, indivisible mass of community property jointly owned with the respondent vice president. Because Philippine civil law legally merges their assets, properties, and income into a single absolute community, it is a legal and mathematical impossibility to determine the respondent's true net worth or lawful income without examining the bank accounts of her husband. Investigating Mr. Carpio's financial records is therefore not an unwarranted intrusion into a third party's privacy, but an absolute legal prerequisite in determining the actual aggregated wealth of the respondent. The defense likewise invokes the Data Privacy Act, classifying the records as sensitive personal information, requiring strict scrutiny, quote-unquote, citing Zoleta versus Ombudsman. The court, however, in Zoleta did not really use the phrase strict scrutiny, but said strict adherence to the Data Privacy Act. Accordingly, Section 16B of the Data Privacy Act expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of the DPA, Data Privacy Act Implementing Rules, expressly permits the processing of sensitive information, personal information, when provided to government or public authority pursuant to a constitutional or statutory mandate, and when necessary for the protection of lawful rights, interests in court proceedings. Now, as to the 21 listed corporate entities and partnership, the requests are granted with respect only to 19 corporate entities and partnership. The respondent's connection to these entities is prima facie shown by the general information sheets in the articles of partnership, which have been pre-marked in evidence, and by her admitted sal-ens from 2022 to 2025. The request, therefore, is not considered as a fishing expedition, and subpoenas may issue for their peso-denominated accounts strictly only in relation to Article 2. However, the requests directed to banking institutions concerning JTC Group of Companies and Pikimong Philippines Corporation are denied. Their general information sheets do not identify the respondent or her spouse as shareholders, and the prosecution at this time failed to show either a direct business interest or a clear and convincing basis to disregard their separate juridical personalities. As held in Pantranco Employees Association v. NLRC, GR 170689, and Lanuza versus BF Corporation, GR number 174938, The corporate veil may not be pierced on mere suspicion or speculation. Misuse of the corporation as an alter ego, conduit, or instrument of fraud must be clearly established. Absent such proof, these entities cannot be subjected to the compulsory process intended for another. As to the request for subpoena against the partnership of Carpio lawyers, the same is granted with the following reservation. In adherence to Subido versus Pagante Certeza Mendoza and Binay Law Offices versus Court of Appeals, GR number 216914. The chair notes the practical reality that an examination of a law firm's bank accounts may incidentally disclose sensitive information relating to its clients and legal engagements. The court acknowledges that the partnership and/or the clients of Carpio lawyers may seek appropriate remedies and to challenge compliance with applicable legal requirements, particularly in light of the potential legal implications, including concerns relating to attorney-client privilege, which may also be raised during the trial proper. Furthermore, the court must draw a legal firm line regarding foreign currency deposits. Foreign currency deposits are governed by Republic Act number 6426, particularly Section 8, which recognizes only one exception to confidentiality, the written permission of the depositor. This is also guided by the President arising from the 2012 Corona impeachment trial. On February 19, 2012, the Supreme Court issued a temporary restraining order in PS Bank versus Senate Impeachment Court, GR number 200-238, enjoining the Senate from opening the Chief Justice's Corona dollar accounts in the absence of a written waiver of the depositor. Accordingly, insofar as the request covers foreign currency deposits of the respondent, her spouse, separately or jointly, as well as the corporation and partnership, it is denied. Such accounts shall be excluded unless and until a written consent of the respective depositors is produced. The court now turns to the records held by the AMLC or Anti-Money Laundering Council. As to the request directed to the Anti-Money Laundering Council, the same are granted with respect to the respondent, her spouse, and the 19 entities and one partnership for which a prima facie connection has been shown through the pre-marked general information sheets, articles of partnership, and the respondent's admitted salens. However, the requests as to JTC Group of Companies and Pikimong Philippines Corporation are denied for failure at this stage to establish a prima facie link, the respondent or her spouse and said entities, or any sufficient basis to disregard their separate juridical personalities as previously stated. The defense vigorously argues that the AMLC is absolutely shielded from this court's compulsory process by the confidentiality provisions of Section 80 of the Anti-Money Laundering Act, as amended, and warrants that compliance would expose AMLC officers to criminal sanctions for breach of confidentiality. The court, however, finds this argument unavailing. Section 8A regulates unauthorized and arbitrary disclosures by AMLAC personnel. It does not and constitutionally cannot nullify the lawful subpoena powers of the Senate sitting as an impeachment court, where compliance with the lawful constitutional subpoena is a justifying circumstances that, if at all, would extinguish any penal liability under Article 11, Paragraph 6 of the Revised Penal Code for any person acting in obedience to an order issued by a superior or some lawful purpose. In the landmark case of Republic versus Sandigan Bayan, GR 2322724, the Supreme Court explicitly rejected the AMLC's attempt to quash a subpoena ducis tecum, ruling verbatim, quote, "The Anti-Money Laundering Council is not merely a repository of reports and information on covert and suspicious transactions. It was created precisely to investigate and institute charges against those suspected to commit money laundering activities. The criminal prosecution of such activities would be unduly hampered if we were to prohibit it from disclosing such information. For the Anti-Money Laundering Council to refuse disclosing the information required of it would be to go against its very function under the law." Further, as held by the Supreme Court in Sabio versus Gordon, GR number 174340, by parity explained that statutory provisions on confidentiality and exemptions from inquiry cannot be invoked to deny access to information by Congress in aid of legislation. It is therefore the position of this court that if the Sandigan Bayan, pursuant to its subpoena powers, cannot be denied AMLC records, as well as the legislature in aid of legislation, It most certainly cannot be denied to the Senate, sitting as an impeachment court. The defense also vehemently objects to the production of AMLC documents by pointing out to the agency's own printed footnotes, which restrict the reports for intelligence purposes only, quote unquote, and explicitly state they are not to be used as evidence in any formal proceedings. The court, however, overrules this objection. The admissibility and evidentiary weight of documents in an impeachment trial are determined by the Constitution, the rules of court, and the judgment of the impeachment court, not by unilateral disclaimers printed by an executive agency on its letterhead. An administrative footnote or internal intelligence sharing protocol cannot rise to the level of a constitutional or statutory exclusionary rule. While the MLC's internal protocols are validly designed to prevent premature leaks during ongoing investigations, they cannot legally operate to tie the hands of the impeachment court once the documents are lawfully subpoenaed. Because the requested suspicious transaction reports and covered transaction reports satisfy the threshold of prima facie relevance in tracing the alleged accumulation of unexplained wealth under Article 2, they shall be produced. The defense further invokes the 5-year record retention period under the AMLA regulations. The 5-year period is a minimum mandatory retention requirement imposed on covered institutions. It is not an absolute prohibition against keeping or producing all the records. Accordingly, let AMLC invoke this limitation in its return, which this court shall take into account and inform the parties thereon accordingly, should they be unable to comply with the subpoena. As for the partnership of Carpio lawyers, Section 1 of Republic Act No. 10365, amending Section 3A7 of Republic Act No. 9160, treats as covered persons those including lawyers who manage client money or assets, manage bank savings and securities accounts, organize contributions for companies, or create, operate, or manage judicial persons or arrangements. Section 2C of AMLC Regulatory Issuance B No. 1, Series of 2018, adopted on May 10, 2018, and filed on June 13, 2018, expressly reiterates this activity-based rule. The court recognizes the statutory exception for lawyers acting as independent legal professionals, where the information concerns their clients or disclosure would compromise client confidences or the attorney-client relationship. Absent any showing, however, that the particular record sought contained such information or would compromise a protected confidence, the exception cannot be invoked merely because the entity concerned is a law partnership. It protects client confidences. It does not confer a blanket immunity upon every financial record bearing the law firm's name. The request for the issuance of subpoenas for the identified financial records, therefore, pertaining to Carpio lawyers is granted, subject to the remedies in law and/or their legal right to assert a specific claim of privilege over a particular document at the proper time. No generalized blanket invocation of attorney-client privilege should exclude compliance at this time. Therefore, to summarize, the court rules as follows. The request for subpoenas directed to the concerned banking institutions covering the accounts of respondent, Attorney Manasseh Carpio, separately or jointly, the partnership of Carpio lawyers, and the 19 listed corporate entities is granted. The banks are ordered to submit to the clerk of court the documents on July 30, 2026 at 9 a.m. with the attendance of parties and counsels. The request, insofar as it seeks the records pertaining to JTC Group of Companies and Pikimong Philippines Corporation, is denied for failing to establish prima facie relevance. The subpoenas granted shall apply only to peso-denominated accounts relevant to Article 2. Foreign currency deposits are excluded absent the written consent of the respective depositors. The subpoena directed to the Anti-Money Laundering Council covering respondent Attorney Manasseh Carpio separately and jointly with the respondent, the partnership of Carpio and lawyers, and the 19 listed corporations and entities is granted. The request, insofar as it seeks records pertaining to JTC Group of Companies and Pikimong Philippines Corporation, is denied for failing to establish prima facie relevance. Finally, the court is cognizant of the Supreme Court ruling in Almonte v. Vasquez GR 95367, where it stated that a government privilege against disclosure is recognized with respect to state secrets, and it is not amiss to state that even matters of national security have been inquired into in appropriate in-camera proceedings by the court. Therefore, the court ex abundante ad cautela or out of an abundance of caution hereby directs, in order to prevent the unwarranted exposure of sensitive AMLC methodologies and information, to submit the records strictly in camera to the presiding officer through the clerk of court first on July 30, 2026 at 9 a.m., who shall review these documents privately before turning them over to the parties as may be warranted. The parties are directed to be represented by counsel on the aforementioned time and date for the proper inspection, comparison, photocopying, and or marking of these documents as the case may be. So ordered. Moving now on. BR. The impeachment court will now resolve the prosecution's request for the issuance of subpoena dated July 6, 2026, directed to the Commission on Internal Revenue. At the outset, the presiding officer reiterates and adopts by reference the court's citation of applicable rules regarding the issuance of subpoena ducis tecum, which forms an integral part of this order. The foregoing standards are deemed reproduced and shall govern the court's disposition of the present subpoena requests. After examining the records sought, the court finds that the requested documents meet the requirements set forth. They are reasonably described, readily identifiable, and prima facie relevant and material to the allegations under Article 2. However, the court, similarly, requests insofar as it seeks the records of JTC Group of Companies, Philippines Inc., and Pikimong Philippines Corporation. The prosecution failed to establish a prima facie nexus between these entities to either the respondent or to her spouse. The records sought, therefore, do not at this time satisfy the requirement of prima facie relevance under Rule 21 of the Rules of Civil Procedure. The court also resolves the respondent's objection to the requested period from 2007 to 2021. They anchored their opposition on the Supreme Court's pronouncement in Duterte v. HOR that the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. The argument, as stated earlier, fails because first, the documents requested under the subpoena ducis tecum will not be used to allege additional impeachable offenses. This court will not allow it. For the same reasons discussed in the court's earlier order, consistent with the same jurisprudence which are hereby adopted by reference, the court likewise holds that the requested records are sought to establish respondents' financial baseline and capacity only, not to inquire into or prosecute alleged impeachable acts occurring outside the present articles of impeachment. Accordingly, these records are required to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. We are also not without precedent. During the Corona impeachment trial, the Salens, prior to his appointment as Chief Justice in 2010, were presented on the January 18, 2012 hearing of the court. Likewise, evidence and testimony concerning properties and transactions before his appointment as Associate Justice were presented before the court on March 13, 2012. Therefore, the production of records from 2007 to 2021 is therefore allowed and authorized strictly for purposes of establishing a comparative baseline only. They shall not be used as proof of another independent impeachable offense. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term. The defense's invocation of the Race to the Privacy Act is likewise unavailing. As previously stated, Section 16B of that law expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of its implementing rules expressly permits the processing of sensitive personal information provided to government public authority pursuant to a constitutional or statutory mandate and when necessary for the protection of lawful rights and interests and court proceedings. The court is likewise unconvinced by respondents' argument that the issuance of the subpoena will usurp the authority of the BIR under Section 5 of the NIRC. This court is not determining the tax deficiencies or civil liabilities which remain within the province of the BIR. It is exercising its constitutional mandate to determine public accountability under the articles of impeachment. Neither does the pendency of a BIR audit suspend or limit the Senate's exclusive jurisdiction to try impeachment cases. The respondent invokes Section 270 of the National Internal Revenue Code to prevent the production of the requested records. The objection is overruled in part. The Supreme Court expressly ruled in Dipad v. Spouses Olivan, GR 168771, that Section 270, quote, of the NIRC obviously does not address the confidentiality of ITRs. It merely penalizes the unauthorized disclosure of taxpayer information, except as otherwise provided for by law. It does not bar the production of the documents. However, the respondent correctly invokes Section 71 and other provisions of the NIRC, which recognizes only 3 instances in which a taxpayer's records may be opened for inspection. Number 1, upon order of the President or authorization of the President. Number 2, upon the request of a foreign tax authority with the approval of the President. Or number 3, upon the taxpayer's waiver. Nevertheless, the existence of these statutory limitations does not at this stage preclude the issuance of the requested subpoena. The issuance of subpoena is merely a preliminary procedural step and does not by itself authorize the disclosure, inspection, or admission of the requested tax records into evidence. In fact, this issuance is the order that shall set, if at all, things in motion. Upon service, the BIR Commissioner may refuse compliance, very much like what they did with the House, or comply by invoking any of the exceptions under the NIRC as previously mentioned, without a satisfactory showing of faithful compliance with any of the enumerated exceptions. This court shall not receive any subpoenaed records from the BIR, similar to what was done when the sealed box ordered by this court to be returned to them. There is also a precedent during the 2012 Corona impeachment trial. The Senate issued a subpoena and thereafter awaited the return of the BIR Commissioner. The requested records were produced only after the requisite presidential authorization had been obtained, one of the recognized exceptions under Section 71 of the NIRC. The respondent, however, is not without recourse nor remedy. In the event the requested tax records are lawfully produced pursuant to any of the statutory exceptions, the respondent may at the appropriate stage of the proceedings raise any and all objections concerning their relevance, materiality, authenticity, admissibility, and other evidentiary infirmities. The issuance of subpoena should not be construed as a ruling on the admissibility of the documents ultimately produced. On this basis, the subpoena shall therefore be issued, and we shall await the return of the BIR Commissioner, at which time the court shall take such action as may be deemed necessary and appropriate. Accordingly, in view of the foregoing, the request for the issuance of subpoena directed to Commissioner Carlito Martin R. Mendoza of the BIR is hereby granted. The request insofar as it seeks the records pertaining to JTC Group of Companies, Inc. and Pikimong Philippines Corporation is hereby denied for failure to satisfy the requirement of prima facie evidence. The Commissioner is directed to make the appropriate return to this court in accordance with the law on July 30, 2026 at 9 a.m. before the Clerk of Court. The court shall await the return before taking any further action as may be warranted. The parties are likewise directed to be represented by counsel on the aforementioned time and date for inspection, comparison, photocopying, and or marking as the case may be. So ordered. Senator Judge Alan Cayetano is recognized.
Thank
you were
you
seeking
for that
recognition earlier.
exhaustive ruling, Mr. Presiding Officer. I won't ask you to repeat it. Because you explained both in the caucus and here that there are only 2 motions, there are parts, I'm talking about myself first, but I think some feel the same way. There are some parts that we agree, some parts we disagree. For example, to subpoena the certain records between 2022 to 2026. Then in my case, I agree with the know your client opening balance just for reference so that you have a starting point. So may I suggest that instead of objecting, I don't know if I'm alone or with others, I will not manifest anymore, but may I submit in writing which parts of the ruling I disagree, and if anyone wants to either manifest or submit in writing. But I do have one question to the presiding officer. So you narrated everything. In the page 2 of the request for subpoena for 004, nakalagay, all records filed with, submitted to, or maintained by the BIR for taxable year 2007 to 25, including but not limited to. So sinabi 1, 2, 3, 1 and 2, pero not limited to. The other one, 4, page 4 of the request number 004-2026. Sorry, that's the case number. So the other one is to the, this one's to the anti-money laundering. Nakalagay po sa page 4, and all other relevant documents. So I just like to ask, was your narration exclusive? Because you did say that it's specific enough, but I don't think specific yung all other relevant. The test of if it's definite is that wala nang iisipin yung pinadalan mo ng subpoena. So kung anong nire-rate, yun ang kukunin.
That is a common practice perhaps used by lawyers, but the understanding of the court, and let this be part of the ruling of the court, is that only the documents specifically mentioned
Thank you for that.
and will not include that catch-all phrase, because I doubt too if the banks, the BIR, AMLC, would be able to supply the and such others unless it was specified.
So with the permission of the court, I'll submit my, where I agree and disagree.
Permission granted, and any other senator judge who wish to submit the written explanation in regard to the twin orders may do so. Senator Judge Marcos and Legarda are both raising their hands, so the same applies to them. Submit. Senator Judges Marcos, Legarda, and Villar Camille are manifesting that they will be submitting their manifestations in regard to the twin rulings of the court, and the same is allowed and will be made part of the records. For the information of the court, yes, Senator Judge Pia Cayetano is recognized. What is your pleasure, ma'am?
Mr. Presiding Officer, I'll just make a short manifestation because
The lady may proceed.
Alan's written submission might be so long, it might just be easier for me to make my own manifestation. Para tumawa naman kayo, guys. Sobrang seryoso natin. But it is a serious topic. Very simply, Mr. President, personally, on the issue of the dates, no, for the submission of the, what was it, 2007? Goes back as 2007 to 2026. And the term of the Vice President in question is 2022 to 2026. My humble position is, and I'm cognizant of the case that was cited by the prosecution. I also found that my own research, the presiding officer used it in the justification of the decision, says that you go back to set that baseline. I understand that. Madali naman siyang intindihan. Ang sa akin lang naman, in the interest also of considering the rights of the person under trial, we could have considered starting at 2022, and if there's more than, kung dun pa lang, it already shows that unexplained from 22 to 2026, there may be no reason to go back and at least respect that part of the record. So yun lang naman ang sa akin. Kasi hindi naman mahirap na tingnan yung 2022 to 2026. O hindi mo makita yung baseline pero may trend. Then dun, saka tayo pupunta doon. Diba? That's our way of showing respect also for the persons who are brought here to trial. But anyway, we submit to the ruling. I just wanted to explain that that could have been a middle ground, Mr. Presiding Officer. Thank you.
Noted and well taken, Senator Judge Pia Cayetano. Chair would now like to take up some administrative matters. We are in receipt of a motion to set conference for the transfer of markings and comparison of video exhibits filed by the prosecution. Since this was received only last Friday, the court was not able to act on it on their requested dates. Court therefore sets this to July 21, tomorrow at 9 a.m. Due notice is given to both parties for this purpose. Likewise, the court is in receipt, the presiding officer rather, as well as the Senate President, of a letter of manifestation signed by Senator Judge Marcoleta, citing a rule in the Arab impeachment trial and wanting his vote to be considered. Chair, the presiding officer in this court will not act on it at this time, but instead, since we will be resuming next week, we'll be referring this matter to the Senate as a legislative body, given that it's the Senate that will be amending the rules to allow participation through a vote. Because apparently, as pointed out by Senator Judge Marcoleta, during the Estrada impeachment trial, a rule was adopted, which we are confirming, that allows the Senate President to provide a mechanism by which a senator who cannot vote under any unavoidable circumstances to cast his vote on any matter. But since this impinges upon the rules of the impeachment court, this matter should properly be taken up by the Senate as a legislative body. And whatever decision the Senate will have as a legislative body, the court shall implement it. But let it be placed on record that personally, once we convene the Senate as a legislative body, I am inclined to agree with the suggestion of Senator Marcoleta, for as long as there is no suspension, according to him. Yes, Senator Judge Cayetano.
I'll not object to that at this point in time. Just as an additional information, I think Senator Estrada elevated to the Supreme Court the denial of the Sandigan Bayan to allow him to attend. But may you also refer my previous manifestation that as a court, we can also communicate whether it's with the Sandigan Bayan or the... But if you're going to say it's going to be through the rules, that's not in conflict. But maybe we can take it up whether in caucus once the Senate convenes.
The point of Senator Judge Allen is well taken. We shall do so at the appropriate time. Now, on other matter, Senator Judge Padilla is recognized. What is your pleasure, sir?
Mahal na tagapamahalang hukom, patungkol po doon sa nangyaring ruling, nais ko lang po sanang magmanifesto.
The gentleman may proceed.
Ginoong tagapangulo at mga kasama, matagal ko na pong isinusulong ang freedom of information dahil ito po ay bumagsak sa aking komite. Ito po ay tunay na kailangan natin sapagkat dito po talaga natin mapapatunayan yung sinasabi nating public trust. Pero meron din po kasing napakahalaga yung tinatawag na equal protection of the laws. Sang-ayon po sa Artikulo 3, Section 1 ng ating Konstitusyon, Bill of Rights, ang nagsasabing hindi dapat alisan ng buhay, kalayaan o ari-arian ng sinumang tao ng hindi kaparaanan ng batas. Ni pagkaitan ang sinumang tao ng pantay na pangangalaga ng batas. Ang mga pamantayang ginagamit natin ngayon ay dapat pareho ring ipinatutupad sa lahat ng impeachable officials, anuman ang kanilang pangalan o posisyon. Hindi ko po makakalimutan ang naging pahayag ng dating Senadora Miriam Santiago dito mismo. Siya po ay isang huwes at ginagalang na propesora ng batas. Ang sabi niya, constitutional analysis is a technical field. Ang pagsusuri sa konstitusyon ay hindi isang sining. Isa itong technical na larangan. Hindi po dapat ito ini-interpret ng basta-basta o kailangan may due process. Nung una ko pong narinig kanina na ipaliwanag po ng ating Senator Judge Alan Peter Cayetano, tinanong sa prosecution kung ganito rin ba ang ginawa nila noong may impeachment kay Presidente Bongbong Marcos. Napakalinaw po na ang sagot nila ay hindi naman sila nagtanong. Hindi sila nagsaliksik kung paanong ginagawa nila ngayon sa pangalawang Pangulo. Ang akin po lamang, makatarungan ba na hindi parehas ang trato natin dito? Dapat sana parehas eh. Kaya po, ang hinihiling ko sa atin, total naman, lahat naman kayo ay sumang-ayon na sa Freedom of Information Bill ko. Hindi pa nga lang nagsasubmit ang House of Representatives. Bakit kung ganito ang pamantayan natin, edi buksan na natin lahat ng bank records natin. Lahat na. Tayong lahat ay buksan na natin, lahat. Para mapakita sa taong bayan na wala tayong kinikilingan dito. Ito ay oras na para samantalahin natin ang pagkakataong ito na ipasa yung FOI. Kasi kung ganito, na parang meron tayong tinititigan sa tinitingnan, hindi maganda ito para sa taong bayan. Tandaan po natin, pantay-pantay tayo sa harap ng Diyos at ng batas. At hinihingi ko po sa inyo na ilagay sa record ang aking pagtutol sa ruling na ito. Maraming salamat.
For the record, there is a pending bill as well requiring all public officials filing a SALN to execute a waiver in favor of relevant government agencies together with their SALN on top and in addition of the FOI bill filed by the Honorable Padilla na tinatalakay din po natin sa ngayon. Before proceeding on one more matter, may I inquire from the lead prosecutor or someone from the panel of prosecutors who their intended witnesses will be for tomorrow and Tuesday? Sorry, tomorrow and Wednesday. Forgive me.
Your Honor, our intended witness for tomorrow is Attorney Melvin Matibag, the NBI Director. And for Wednesday, Your Honor, it will be Marivic Pareha of the Legislative Archive Office of the House of Representatives, Your Honor.
And on Wednesday, the bank officials?
In addition, Your Honor, but considering that we only have Tuesday and Wednesday for trial, but after Marivic Pareha, we will also be presenting the two land bank officials, Your Honor.
Yes, because we issued a subpoena ad testificandum against these two bank officials to attend tomorrow and Wednesday.
Yes, Your Honor.
So for the information of the two bank officials, if they are listening, they may simply attend the Wednesday trial, not the trial tomorrow, although the subpoena indicates tomorrow and Wednesday. Would that be okay, counsel for
Yes, Your Honor.
panel for prosecutors? Lead prosecutor, rather? Yes? So Attorney Melvin Matibag tomorrow, and if at all, Ms. Marivic Pareha and Ms. Marivic Pareha and the two bank officials on Wednesday. Counsel for the respondent, ma'am?
Good afternoon, Your
What
Honor.
is your pleasure, ma'am?
May I be recognized, Your Honor?
Yes, ma'am. This is regarding what matter, ma'am?
Just two administrative matters, Your Honor. The
Please,
first
ma'am.
one with respect to the motion to set conference for the transfer of marking and comparison of video exhibits. We would also like to request that the respondent be allowed to also mark additional documents at the appointed time tomorrow. In effect, we're asking
Also at
the
9
same
o'clock.
latitude. Yes, Your Honor. In fact, some of the documents that we intend to mark tomorrow would be also our copies of some of the listed items in this motion, Your Honor.
Of
And-
course, that motion already made by counsel for respondent is hereby granted. The respondent, in similar fashion to the prosecutor, may also mark
Thank you, Your Honor.
or change the markings or mark any pieces of evidence they wish to do so in order to facilitate the trial. So ordered.
Yes, thank you, Your Honor. And just to place on record the additional marking of evidence and whatever transfer of markings to the prosecution will do tomorrow is without prejudice to Section 3, Administrative Matter Number 2026-001 of this impeachment court with respect to the guidelines for the conduct of the pretrial conference, which explicitly states that the marking is without prejudice to any questions on admissibility, relevance, etc., Your Honor.
That is the understanding, counsel, yes.
And the second
The
matter,
chair
Your
confirms that.
Second matter, Your Honor, with respect to the earlier ruling given by this court on the two requests for subpoena, Your Honor, defense requests for certified true copy of that ruling, Your Honor. Thank you.
Chair will address that. It will be included in the journal. However, the journal will have to await the manifestations to be submitted by any senator judge who may agree or disagree with the ruling. So we might not be able to approve the journal tomorrow, although we will do as best as we can. But as soon as the journal is approved, we shall make it available. But the TSN can be made available perhaps by tomorrow.
Thank you, Your Honor. That's all, Your Honor.
Your Honor, may I make a short manifestation with regards to the order of presentation, Your Honor, earlier mentioned by the prosecution?
Of witnesses?
Yes, Your Honor.
Subject to the limitation mentioned by Senator Judge Allen the other week, if you remember.
Yes, Your
counsel,
Honor, I understand.
the lady may proceed.
We are maintaining the presentation of NBI Director tomorrow, that is Tuesday, July 21. And then following the NBI Director, Your Honor, will be the two land bank managers in the person of Violeta San Constantino of Shaw Branch Manager and Denita Camposano of DepEd Branch Manager. As to the presentation of the Legislative Archive Officer, we will be determining the appropriate time when to present her, Your Honor.
So the court recalls or withdraws the earlier statement that the two bank officials may appear on Wednesday. The subpoena stands, therefore, requiring their appearance to respond to the subpoena ad testificandum tomorrow, July 21 and July 22.
We confirm, Your Honor.
So noted. Any other matters that any of the parties wish to raise? There being none, since we did not have a break, trial is hereby adjourned until July 21, Tuesday at 2 p.m.
WRB News FM 103.9 ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman at mga pinakahuli at sariwang balita sa loob at labas ng bansa. DWRB News FM ang himpilang ikaw ang una. Ikaw ang una. WRB News FM 103.9 ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman at mga pinakahuli at sariwang balita sa loob at labas ng bansa. DWRB News FM ang himpilang ikaw ang una. Ikaw ang una. WRB News FM 103.9 ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman at mga pinakahuli at sariwang balita sa loob at labas ng bansa. DWRB News FM ang himpilang ikaw ang una. Ikaw ang una. WRB News FM 103.9 ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman at mga pinakahuli at sariwang balita sa loob at labas ng bansa. DWRB News FM ang himpilang ikaw ang una. Ikaw ang una. DWRB News FM 103.9, ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman, at mga pinakahuli at sariwang balita sa loob at labas ng bansa. DWRB News FM, ang himpilang ikaw ang una. Ikaw ang una. DWRB News FM 103.9, ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman, at mga pinakahuli at sariwang balita sa loob at labas ng bansa. DWRB News FM, ang himpilang ikaw ang una. Ikaw ang una. DWRB News FM 103.9, ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman, at mga pinakahuli at sariwang balita sa loob at labas ng bansa. DWRB News FM, ang himpilang ikaw ang una. Ikaw ang una. DWRB News FM 103.9, ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman, at mga pinakahuli at sariwang balita sa loob at labas ng bansa.
Ang ating ginagamit na rules ngayon. Pwede po ba yung mga problema po labas sa impeachment court na ito o labas sa kaso ng Vice President ay dadalhin natin dito? Di po ba ang korte na ito na itatag para po sana kay Vice President at kay Vice President lamang? Mga ebidensya, mga testimonya, mga pahayag patungkol lamang po sana sa impeachment ng Vice President. Kasi dito pong mga nagdaang araw, Mr. Presiding Officer, Senate President, mga kasama, napansin ko po na nagagamit ang oras po ng impeachment court sa pagtatanggol po ng mga nakaraang araw ng sarili ng ilan sa mga kasamahan natin sa mga akusasyon. This is not the right forum and the right venue and not the right time to explain your situation. Kung gusto po ninyong mag-eksplika ng inyong mga saloobin, problema, maaari naman po ninyong gawin yan sa labas po ng oras ng impeachment court. Maaari pong sa press conference, nandyan naman po ang Senate media. Anytime po, nandoon sila sa Senate briefing room, press briefing room. Maaari din po sa Facebook o sa YouTube magpaliwanag. Huwag po nating gamitin ang oras ng impeachment court sa pagpapaliwanag o sa pagtatanggol ng ating mga sarili simula pa po noong nakaraang linggo. Because the time we waste here to defend ourselves, defend what we believe or what have you, is an injustice to the Vice President. Yung oras po na ito dapat ilaan natin sa pakikinig sa depensa ng Vice Presidente, sa mga akusasyon laban sa Vice Presidente, hindi po pagdidepensa sa mga sarili natin kung tayo inaakusahan ng kung anong mga ahensya, kung tayo po ay may mga kaso, may mga investigasyon. This is not the right forum, Mr. Presiding Officer, Mr. President, Senate President. This is not the right place. This court was established, was created, the impeachment court, for the Vice President and Vice President only. This should be her time. This should be her forum, not our forum here, na ilabas natin ang saloobin natin, mga sagot natin sa mga akusasyon, mga kaso laban sa atin. And this is not also the time, Mr. President, Mr. Presiding Officer, na hanapin yung mga kasama nating nawawala, nakakulong, dapat po doon sa Senado natin, sa sesyon natin, and not here in this court, Mr. Presiding Officer, Mr. Senate President. Kaya pakiusap ko lamang po sana sa ating mahal na Presiding Officer and Senate President, let us follow the rules. May rules po tayo. Kung hindi naman ho patungkol sa Vice President na sasabihin natin, hindi naman po patungkol sa depensa o prosekusyon ng Vice Presidente natin, then wag na ho natin payagan na magsalita pa po dito because nasasayang. Because every minute, every hour that we waste away from the defense or from the prosecution of the case of the Vice President, it is injustice. It is called injustice to the Vice President, to her family, yung anguish, yung kanyang sama ng loob, yung oras na nakabinbin ang kaso na ito. Let us do this impeachment trial as quickly as possible. If we have to clear the Vice President, then let's clear her. If we have to prosecute, then prosecute her with the evidence kung meron. Not waste our time kung ano-ano sinasabi natin dito to protect ourselves, to defend ourselves. This is not the right forum, Mr. Presiding Officer.
Kindly wind up,
Mr.
Senator
Senate
Judge
President.
Erwin Tulfo.
This is not the right forum for us to defend ourselves. Bring it somewhere else. Bring it to the press. Bring it to the social media, but not here. Thank you, Mr. President.
Senator Judge Erwin Tulfo is concerned about the justice or injustice to Vice President Sara. That's good news. Regarding the waste of time here, sabi ni Senator Joker Arroyo, it is useless to argue a legal point with a non-lawyer. When Senator Marcoleta
WRB News FM 103.9 ang himpilang magbibigay ng mga impormasyon sa larangan ng edukasyon, kalusugan, pangsakahan, kapaligiran, musika, natatanging kaalaman at mga pinakahuli at sariwang balita sa loob at labas ng bansa. DWRB News FM ang himpilang ikaw ang una. Ikaw ang una. DWRB News FM 103.